Last time I was out here with a mountain of poo-poo.
Yeah, he's got all that.
He has a website for it as well. Maybe we could make
Nathan from Bolton?
No, from
No,
Africa.
Nathan from Boise.
so maybe we can stick it on his site, granted permission, if we could maybe communicate that with him,
Well, yeah, we can.
if that's all right.
Or
And so we can have another central station that can, you know, send
Download.
somebody if they need something, if they want to watch this, if they want a copy of it. I'm okay with that, if we're all okay with that.
Well, I have a club in Edmonton that probably they're gonna be.
Distribute it any way we can, people, please.
you don't want this on YouTube, though.
No.
Anything I say is a lie,
I like
and I got one judge.
Yeah.
He's right here. And I'm gonna be true to that guy.
All this paper just to convince us of who we really are.
I appreciate that. Could you say it loud and clear before I
All this
become your
paper
father?
Just, yeah. To convince us of who we really are.
Chocolate?
Well said. Negative. Thank you.
Chocolate?
Oh, thanks.
We need to stay civil in all matters. That, especially even little children upset us. Because I think we were asked to protect the smallest of creatures.
Yeah, my oldest son, he got on me one time and I blew up at him and he went away and sat there and cried and I said, I'm turning into my dad. I went and sat down beside him for 4 hours. I'm sorry, forgive me.
Thank you for that, Gord. Thank you. There's the Gord I want to see more of.
Sorry?
There's the Gord I want to see more of.
Yeah. Me too.
Then we're getting there.
Yeah.
Good. Good. I'm going to fold this up and maybe we'll spread that out and we can sort of tear it apart and add to it if we're okay with that.
The checks?
Was it?
Exchange for credit only or Bank of Canada notes non-negotiable at par value.
We want to get to that.
Discs. Put your water back here? Sure.
I was asked before we left to go over 579 of this. I'd like to touch that just before we do open up. Does anybody recollect 579? Does it have anything to do with
The Attorney General may direct.
a what?
A stay.
Of-
Directs.
Of?
Proceeding?
Yeah, let's take that word, proceeding.
Proceeding.
What is the word proceeds? Hidden in there? Hidden in there? Proceeds. Thank you. A stay of monies. A stay of it going transacted from one side of the ledger to the other.
574?
79.
579. Recommencement of proceedings.
I paid the bonds, that's why they would have typified.
You created a poundage fee and you haven't claimed it, so you landed it, you gave it right of entitlement to sell it on the open market.
Oh yeah, what's that poundage fee specifically? That's creating your paying substance with the silver dollar.
Yeah, you would create a trust with a deputized individual under a common law contract.
And now he's obligated to fill his office. And that's what I'm saying, now what is the exact job of the sheriff?
It's a good question. He or she has been employed to guard specific zones in the courtroom, and that, plus transporting prisoners, that is his duty. It
What
is
about
not-
out on the highway and things like that? A sheriff, like in the
They're
ancient times,
engaged
what was
at
the
that-
sheriff's job?
Yeah, they're engaged to go pick up the property.
Well, there's a sheriff running on the highway right now.
Okay?
And they act as
I can't figure that out, because the sheriff in Alberta are appointed under the Solicitor General's office, under the Solicitor General's office, and their sole purpose is civil enforcement.
Civil.
Civil enforcement.
Which isn't sheriff, is it?
But now they've got these sheriff's cars running around on the highway.
And peace officers as
And
well.
peace officers too.
Well, they're all under the peace
Well,
officer.
it says sheriff on it, and then on the bottom rocker, it says peace officer.
Yeah, and some just say peace officer.
Yeah, well, because underneath.
Anybody seen the sign Rotary Club when they come into town?
Yeah. Rogation.
Ever heard of rogatory?
Letters.
Letters
From one court to another.
Letters of rogatory.
Letters are
Yeah,
to
rogatory from one court to
Rogatory
another.
jurisdiction.
That's where your court's jurisdiction supersedes theirs.
Actually, it's with them taking their power out on the road for a fishing trip.
Yeah.
One court to another.
A counterclaim for that would be an old charge known as
Barricade. Yeah.
they're inciting a riot. They're creating a war. They're causing the injury by taking the law of the sea and imposing it on the land.
Rogator.
So
Counter-
they're
Counterclaim with a chartered barricade.
Excuse me?
Counterclaim with a chartered barricade.
That would be a set-off claim, now, wouldn't it? A
It's
counter-
definitely an offer. Rogator, the proposer of a law or rogation.
And now let's take the word pundit.
Pundit?
Pundit. Are you a pundit of that? Which means, is that your opinion? It's a Sanskrit word.
Is it?
Chi-
What is it?
Punjabi. It means opinion.
Pundit.
Pundit.
Pundit, the interpreter of the Hindu law, a learned
Brahmin?
Brahmin.
A learned Brahmin.
learned Brahmin.
He's listened to a lot of opinions and managed to formulate a single understanding.
Well, if he's learned, then he must be knowledgeable in the global sense, isn't he? That's like the judges are learned man, wouldn't they?
Yes.
Which is what they assume you to be,
Consolidated opinion.
unless you sort of let them know the difference. If you're an unlearned man, for instance.
Yeah.
Kelly knowledge.
Barricade is A, isn't it? B-A-R-A-T.
Barratry. Thank you.
That's A, I think.
Barratry. Thank you. I appreciate correction. And
A bull. He's a bull.
there's an interesting website, Bully Canada. So they're bullying, getting bullied. Are we getting bullied when we go into court? Are you being a bully, Judge? You're causing me to rest, you know that? Under Criminal Code 335.
Used to. I don't know more, but used to.
335?
Because I joke.
Definition of vessel.
The vessel's being attacked.
Yeah, taking a motor vehicle or vessel, or found herein without consent.
Without consent.
Exception, yeah, without consent.
What does a vessel speak? Doot doot!
That's the only thing the interpretation of, that someone can interpret that way.
Now pull up the vessel. Does it tie right back to the meaning of person?
Yeah.
Yes.
Thank you. Craft, actually.
Craft.
Yeah, ship, actually.
Yeah.
And a ship is mostly known as a vessel. What is a
Citizenship.
ship? Yes.
Oh yeah, because it says here, without consent, owner of the owner takes a motor vehicle or vessel with intent to drive, use, navigate, or operate it, or cause it to be driven, used, navigated, or operated, or is an occupant of a motor vehicle or vessel, knowing that it has been taken without the consent of the owner, is guilty of an offense punishable in summary conviction. So if they accost you and you say, no, don't touch me, I'm not going with you,
Non-consensual taking.
non-consensual taking.
You don't have my consent. As Menard puts it, there will be no resistance of arrest as long as you have clear and lawful authority, which is based on my consent, which you do not have. And I am in peaceable possession of my faculties, so I'm expressing the estate's calmness in peace under 39(1),
Which is repealed.
which has been repealed.
That's it.
Gotta keep complaining enough till you get what you want, my guess is. Or instead of complaining, make a decree and go from there like a royal proclamation.
Yeah.
39-1 though is also, was, left them off the hook. Because remember it says under authority, if you don't have an authority, that's why they can come against you.
Executive's office.
So if I put a 39-1 and I say, come, I'm gonna get this over with at 41-2.
When was it repealed? It's not repealed.
41-2 is second degree manslaughter. I gave you
Right, in the
that.
new criminal code, it's repealed.
I won't be doing time for
Well,
it.
that's
either.
2011,
It'll
and
be
that's
summer
when Dave said it
very-
was repealed.
Not an indictment.
Dave moved.
Just the value of
When you should-
implementing the
Well, they would have to repeal it.
second to die clause in the insurance. Pardon me?
I can't-
Still in there, they could
Yeah,
remove
I
it
can't
for
see
us.
them taking it out of there.
Foreign jurisdiction,
I heard it
go
wasn't in there
to
anymore.
Hague, I'd probably be tried in Czechoslovakia.
That's 2011.
You laugh, but there's interesting
Well,
cases coming
Someone talked
out.
about that, and I said, well, they
The
can't.
paperwork is
repeal
going there.
the principles of the law.
Yeah, I mean, you can look at the top,
Expert
like, here's one, protections of
the market
person under
right now,
authority, number
numbers that
44 was
standard
repealed in
before.
2001.
At the
You
crosswalks, I
don't
can
see a
drop 20
lot
back
of them
on.
until you start getting up into the higher numbers, right? Because these are the basis of
Well, share, I got
law.
entitlement.
Yeah, and the principle is still there. Look at 29. I don't know what it is in there, but 29, when they serve a warrant,
What's that? What was
it
that?
tells you when they serve a warrant that they have to, duty of person
Duty of
arrested.
person arresting.
They have to have it with him where feasible to do so and produce it when requested to do so. Subsection 2, the duty of everyone who arrests a person, whether without a warrant, to give notice to that person where it is feasible to do so, the process under the warrant which he makes the arrest, or the information or whatever, the reason for the arrest. And then 3, subsection 3 says, failure to comply with subsection 1 or 2 does not a self-deprived person of executing the process of warrant or a person who makes arrest or those who assist them of protection from criminal responsibility. So they're not liable because they're just doing their job. They're trustees.
Actually, that applies to the machine.
And so you calmly go with them, and what do you do on the bail bond?
Except for that.
Can?
Under duress?
Yes.
Which they pay no attention
The
to.
old protest.
You gotta present it inside the court, why don't you get a certified copy notarized and stick it in and see what happens? And just go right to that. You blind?
Certified top of under duress, like what?
Yeah, you get a copy of the bail bond when you're released. You gotta appear, so it's an appearance,
Yeah.
it's arrangement, or a marriage to go to the ceremony.
Yeah.
So if you present how you signed it with the word duress, and you hone in his vision, and you get it on the record, what you got?
Yeah, but as I would say that the judge would look at that and say, well, you must be insane because you were really under duress, you just didn't know who you were.
Are you qualified to categorize me as such?
Are you
No, I'm
making-
not, but I'm gonna send you away for that. Can I have that in writing?
Yeah. Are you making a legal determination?
It's a judicial ruling or a legal determination. They're back in the law.
Do you have the right to adjudicate the issue?
You don't answer that, they just sit there and they do the 1001, 1002, 1003. and then-
You're in contempt. I'll say it to him.
And then they turn around and
You're in
go,
contempt.
we will put that off for 3 weeks for,
Oh, you won't.
oh yeah, that's what you gotta do.
Yeah.
But that's what they do. Because they bait, huh? And we suck into it though. Absolutely, you gotta
Bait and
be
fuck.
prepared.
I've been told to stop singing and whistling in court. I thought I was here for the audition.
Huh. I told him.
I got
he
told
said-
to stop reading this.
Did you now?
Yeah.
I got told, for and on the record, you're watching too much American TV.
You got told that?
Yeah.
By the Crown?
Judge. You gotta love when he gets me in there. Mr. Garand has his way of believing the way the law should work, but today he understands, we'll be using my understanding. You walk in like the Chihuahua in the back of the freaking car. We're turning. All right, I'm going along for the ride. I didn't say yes, I didn't say no. I'll get you in half.
I mean, I remember I said, are you fucking deaf or are you just stupid?
Mr. Garand, would you mind taking the stand?
I will not have profanity in my court. I said, define profanity.
I got no problem contracting with the guy behind you. Judge goes, you have so many options when you exist lighthearted. If you weigh yourself down with your own anger, that will lead to your demise. They don't want that for you, and they don't want to see that from you.
See, we used to get this, I don't understand so much, being confident one. Remember Bob, my buddy Curly?
Mm-hmm.
He had this stack of charges. I helped him out, he goes to court, tells him what saying, if the judge don't understand 39-1 and doesn't understand 337. I said, nail him back on section 19, figures of the laws, don't shoot. The judge goes, I don't understand any of what you're talking about, I don't understand.
Thank you for your admission for it on the record, your incompetency. Are you certain you don't understand trust, instruments, laws, and deeds, and contracts?
Bob answers, ignorance is no excuse. No, ignorance is no excuse. That judge was coming out of his seat and I go, no. And he
You
just
guys
come-
offering conclusion.
And also he goes, of the law. And the judge just plunked back, goes, he was coming out there going, like he called, he said, ignorance is no excuse. Oh, man. But it just come out like magic, about 10 seconds of the law. That I thought.
Shut him down?
Oh, it sure did. But just ignorance didn't work.
I drove here this morning, I know I'm not that ignorant.
But that judge, he didn't like to be called ignorant. But then of the law, he shut up.
It creates an injustice to the law if he's misrepresenting an issue.
But they do that. You've had that too. They'll like to say
So, what was that phrase? I seek leave for what?
Interlocutory appeal.
Of? Matter of?
Interlocutory.
Law.
Well,
Interlocutory, because I want his conscience to come with me, not just the paperwork. I need to bring him upstairs personally for what he's concluded without considering my position. That's very inconsiderate. That's non-consensual. That's a Security Exchange Commission indictment. You ever heard of the Sarbanes-Oxley Act? They have a charge known as insider trading or stacking, hedging your bets. Judge pretty well in charge of running the show in there. And just waiting to go NISA 1 into NISA 2.
the racketeering.
or fraud.
You're racketeering.
The bottom line, they're seeking what is an impossibility. You present the impossibility, that creates the doubt. Therefore, you contained the criminal side of the ledger, and now you're implementing professional conduct, which is risk management issues.
Wouldn't that be the same as Mr. Gates there when they're getting him under the Combines Act?
What was his what was his infamous statement? How did he get himself off the hot water?
Who's this?
Gates, he said, I do not make it a habit of making other people's business my habit. Is that the same statement as the estate reserves its right to dispose of its assets as it sees fit? Is that equivalent to testamentary capacity and the wishes of the testator?
Exactly.
Did I use the word will?
Not yet.
Thank you. Am I expressing it just the same?
Exactly.
Is it concise? Is there any ambiguity in those statements?
No. Very concise.
They provoke ambiguity. We must vacate that, and we can only do it from a calm stance. At least that's what I've come to understand, because if I allow rage to command me, I know damn well I'm just about to fall before my pride trips me. There's my ego. I got a big ego. I think we all do.
Gotta keep the ego in check.
Yeah.
Because we wouldn't want to commit fraud and affect the public market.
You see, that's an effluxing on the account. Effluxing. These are terms that the stock exchange understands.
E-flexing.
It's not going to create a proper value. It's going to create a negative value. It's not going to add interest to the trust. It's going to take away from the value of the trust that we are trying to negotiate. How can I trust you if you're a liar? If you come in and claim the name, are you creating a fraud?
Yeah, you can participate in it.
If you stay benevolent to the situation and in the best public interest,
I'm coming and filling the position of the office of the executive.
well, claim the position of no entitlement for attornment. Hey, you trying to sink me if I claim the name? These are just short, quick, whippet questions that fit the situation that can pull your head out of the news. we've had a few people experience a lot of what we're discussing and have had these great invisible trophies. Can I put it that way?
Or surprise packages of shit.
Surprise.
Well, you can always go back to the manufacturer under warranty for that one.
Because as the main principle, you always.
It's pretty hard when you know you did it yourself, eh?
Correct any mistake you made.
Well, I know my shit.
I can smell my own too after a while.
When the pile gets knee deep, you got a little issue, eh?
Sucks though when it's yours though, doesn't it?
Well, I was just talking this morning about how you can have a bummer start to the day when your finger goes through the toilet paper. 579, best interest of public policy. Why? Because this taps into the futures market and it's based on our retirement. Once again, right back to heart. Anybody got the meaning of heart?
Oh, yeah, the acronym.
Please.
Heroes
Heroes
We survived wars!
Retirement.
Yeah.
tax.
I'm entitled to earning something after all that fight. Some assistance, and it's going to come from the retirement funds out of those trust accounts. And I can use them to pay off issues that are presented to me by entitlement.
So it's like 0 to hero as soon as you get this under your belly.
Makes the most sense. You're told that if you're going to draw a weapon, be certain you will use it.
You're gonna use it.
This is not necessary bravado-wise, and I know that we all, once you got a lot of this, you're gonna go in and say, You're gonna try and match your sword.
I don't wanna ever go in there ever again. I just wanna go up.
Get better at the
I
people
wanna
we're
go
going in for, you
spend my
don't have
time out in
to.
the country being a dad.
I'd like to hear about that, Gord. I want that for you.
That's what I wanna do.
Good.
Go ride my sleds and go teach my kids how to shoot their guns and
Kill those damn
ride their
cows.
sleds and ride their quads.
Here's how you track something. You gotta lead. I'm gonna go by on the sled, okay? Getaway car.
It's true, you gotta set the bird seats, Ken. You gotta set the bird seats.
Well, you know. gotta
And
have-
you can't enjoy that unless there's something to fund that with.
Yeah, that's been the problem.
That's a challenge, it's never a problem. I look at things like a problem, I'm stuck at 49. I say challenge, I'm willing to accept a challenge because that's gonna better me. I'm at 51 and I'm going forward. I haven't beaten myself up,
There's no
like
such
I've been
thing
taught to do so.
Yeah, that's
as- No such thing as problems, only solutions.
That's all I wanna
Morning and
offer.
night. No such thing as problems, only solutions. Convince yourself, speak it till you actually feel it.
Yes, I can.
Yeah.
And it's for the public interest, so that's the futures. 579.
And the real party interest is the only one that can recommence.
So then as soon as you're walking in, hopefully there's a paper waiting that you can draw their attention to so you won't find yourself in a tournament. It'll be settled.
You're going to court for the check.
That's one.
579?
I'll go.
579.
That's what I used to say, where's the check? Is there anything else that you
No
need me
problem
to
going to
sign?
court.
Where's
I
the
wanna go
check?
to court.
What's the last one? 794?
794 is your exemption.
Alright, so we covered all those points now, eh?
I feel I have, but I'm open to clarity if there's those that wish to review. You also please consider it is on tape. You can push rewind anytime. Have we checked the audio? Am I okay at this?
Yeah, well,
We're pretty good?
Hank's,
Good.
Hank's got full audio there too.
Yeah, we got 3 audios, I think we're okay.
Okie dokie.
As long as we don't record over them.
Again.
Yeah, see it then.
Don't put that out there.
Thus is the reason a good businessman has nothing on his desk at the end of the day. He's taking care of his issues. He's ready for tomorrow. I do not need this. I'm certain none of you need it either or neither. It's in here already. This is the awakening. Be good avatars.
Well, I said right at the very beginning, you don't need
You can
any
be
piece of
savage.
paper. If you walk
Okay
into
with
that
that.
court, Jesus didn't walk around with a computer and a laptop and paper. You knew who he was.
So you say, I am.
Yeah.
So if you walked in and said, "Money changers!"
Yeah.
Exactly.
Or more contemporary, like Starbucks. Bean counters. Banksters. There you
A
go.
whole lot of you.
CIDC, criminals and bankers clothing.
Yeah. Girl with the banker's clothing, I like that.
Yeah. TD, total distrust.
Total distrust.
Like in Nova Scotia, you're richer than you think you are.
Yeah.
They're not lying.
No.
They were the last ones to offer non-interest bearing accounts. And Nova Scotia is a very interesting place because
of the trees.
the treaties taps back into the Puget Sound one for the slave trade that came up on the East Coast. And now the mercury that goes this way pays back that way through the cappers. And it goes through a Kretzing account, which is for the Nova Scotia African Development Fund.
When we were doing the numbers for the treasury, there's two treasuries in Canada. Nova Scotia and Alberta.
Bingo.
Nova Scotia
I know.
African Development?
I believe that is it. It's the
There's
monies
only
that's
two
going to the
treasuries.
universities.
No
We have the
treasuries.
Eastern Intelligence, and they're also the leader on the market when it comes to telecommunications. For technology reasons, we're giving them the resources because we want that country to develop to a one world
We
country.
were doing, there's
One world order.
I forget what it is.
Canadian Pension Plan is the Canadian Procurement Program.
Not that I told this, yours, one second.
It's necessary because we are developing to take those positions that have been developed for us. FDIC.
Moose Jaw calls for money. They built a new skating rink last year.
For all those.
And they found it,
Clearinghouse numbers.
it's really interesting what they called
Only
it.
two of them.
They just happened to find it. It was in their
One
cemetery.
code out there.
Yeah, well, that's what it's probably talks about.
18 plots
The
per.
cemeteries,
$34 million.
BC Assessments holds those plot numbers. Assessments because it's not finalized. The money is held in those plot cemeteries,
yeah.
like bank accounts.
No shit. Because they have to buy you a lot. So when you do finally expire, they got someplace to bury the evidence. So they keep that little spot there for you.
It's part of the birth certificate, death certificate. Where do you put the corpus?
Hopes of the trust.
Yes.
I wonder if my
in the
grandfather's
trust.
been dead now
Trust
for
depository.
years. If I can still go back as the executor, I think I can.
Actually, I think at this juncture where we have many dearly departed in late form, meaning past 3 years, I'm thinking that with the ability of agreement, as in a pool bond mechanism, the way the market recognizes it, and certain codes, like an MT760, creates a bing instead of a ping on the market. We're not playing the pip spreads, but we're playing trades instead of investments. We're going from automated settlement clearing, or automated clearing settlement system, ACSS, to LVTS, large volume transfer system. So we will effectually make large investments on accounts like that, add to the value of the globe of the world. Remember, Winston often started out in his old information saying, we are fishermen of souls, if you would. There are many spirits about that need that creative love outlet. We suppress the millennium souls. Africa's had quite the suppressive process. See how we're giving the gilt bonds back? It's like the insurance paying out to the right direction. We talk quickly about the 100th monkey syndrome. We're slowly all going to get it.
I'll get the 10%, but
Yeah.
90% get it, don't they? So the other 90 get it.
Square root of 1%. In a given
So
population.
don't ever think you don't got it already, please.
Yeah, all knowledge is already there. It's already in the.
Akashic Records waits for your attunement.
It's just
Change
this.
frequency. Just change
There's
frequency.
DVDs on the top and CDs on the lower stack.
Vibrational
I don't know what you need there.
You emphasized very well how you will get what you will project. Your intent is getting louder. It is coming to an accelerated point where we are affecting financial institutes because we are achieving sovereign understanding.
Yeah, you can
It's really
put
good
oneself in
idea
comments.
to reduce it to writing so that there's no illusions. And
There's the ambiguity that we must cancel. There's the ambiguity that we must cancel. You are correct. It needs to be put in writing somewhere. Written into evidence is the issue.
when you show up in court, if they have an issue and they say, "They're proceeding as if nothing's done," then you can say,
How can the
Did you
court be
receive-
so blind?
well, have you received the documentation? Have you been noticed, and do you understand it? Do you understand the appointments you received? Do you understand that everything was put in place for you to settle this? What needs to be perfected for that process, if anything? And that way, there's nothing to argue with there. Then they can read the paperwork, or you can start reading on the record if you have to.
And if you're denied, what would be an expression that would stop that denial in its tracks? Are you
Russian.
Rush
What?
to judgment?
Thank you.
Is this a rush to judgment?
But the problem we have in the court system,
Challenge.
what they're having, is you need witnesses, the same as writing, if you got witnesses. But if you're going in, you're a member of the court, it's really nothing, it's just like a hearing. That's why the clerk will say the judge's name, he'll never say it, because it's like, you keep them off of liability. But what you have to do in there, if you're gonna put on there, you have to convene the court. Convene means court of record.
Excuse me.
So you're gonna have to convene it, and you're gonna have to pour it on the record, or you may as well do
If
nothing.
we want to go in and deal with it personally,
Or something appears in there when you're in there that happens. You have to have this for your smoking gun. If you did it for something arose, and you want it on there, that's the time when you have to have the cue, convene the court. But once you convene the court, you remember then you have to also adjourn the court, so don't leave it open.
I did that.
very,
I
very,
went out of the
very
courtroom.
paramount point.
I ran back into the courtroom. Oh, I'm sorry, buddy. Court adjourned.
Dawn, a friend of ours, went to court, she convened the court, asked if, she said, I haven't seen it, so she convened it. And she went there and she said what she had to say, she thought, you were there, she sits down. She's done, so they have 2 cases go through, and she goes to him, she goes, I didn't notice him. She runs back up there. You know what happens usually when you run back up in the court.
right there.
And she runs back and goes, oh, I want to notice you that we're on the record, right? And she told him she's going to notice them that if they join her, they'll be held with fraud on both the judge and the court. And he said, she sits back down, but where's this contempt of court? Did you ever see anybody jump up from the audience, run back up there after 2 cases gone through and just start yakking?
Yeah,
But she did not like a judge. She forgot to what?
adjourn the court.
Adjourn. Like I said to her, where was Judge Donna Gandry that day? Right? But the point is, once you convene the court, there's new powers come there. You go try in any court, run up there and start talking to the monkey in the suit. He could eat you alive. But why did she could do that? And everybody, you were sitting there, what did they say? She hollered at the judge. I'm not in this jurisdiction, I do not take orders from you. What did those people say?
There was 2 women lawyers sitting in front of me, and when she said, "I don't take orders from you," the judge never batted an eye. But they went, "Oh,
How could she? How could she?
my lord!"
Yes.
So there's powerful things.
Bad form.
Bad form.
Some people go up and try this stuff, and they forget the important thing, like, you gotta adjourn the court. If you don't, it's not, good may not go good for you, and then you're gonna go, well, I ain't doing that ever again. It don't work. Once you convene, you gotta adjourn.
So can we add those points to what we're definitely going to
Adjourn that too.
develop?
Yep, who's writing that down? Mac?
So you got it what? What are the steps? Is one of them convene?
I thought you were getting all these pieces straight in your head.
Is that right? No convene?
No, I.
No I?
Yeah.
What would be the next?
Oh,
Settle.
cool.
Warrant? Are you warranting the issue?
Yes, if you're settling it.
Then adjourning? Is that like a triple stage thing?
So you're talking
Okay, you're
about
gonna
in
convene the
court.
court, I think the next thing you'd have to do is make sure that you have that
EOL?
Well, EOL.
Is that equivalent to a letter of credit?
Yep.
Excuse
It
me?
is,
That'd be powerful.
that's what it is.
You're above 5 on the ladder of the UCC.
Then there would be the notice of standing, wouldn't it? That I am before this court of record by special appearance or special visitation and by oath of office as the executor without waiving any claims, rights, remedies, defenses, statutory, or procedural.
That's a beautiful entry.
Making it into a court record by that. 'cause
Well,
it
yeah,
was
that
small.
statement, that would be, okay, now you convene the court, now would be standing. So that I am before this court of record by special appearance and by oath of office as the executor and without waiving any claims, rights, remedies, defenses, statutory, or procedural. Now you accept the standing. Now you can.
Gord, whose paperwork is that you're reading from?
This is
Keating?
Keating student, it's that Toby Butterworth, the guy that does.
I'm gonna put Keating in brackets with Gord, granted permission, even though it's non-existent. Thank you, Gord. Arr. That's all you gotta take out in your God.
Gord Keating. Is that your dad?
Gordon Keating, yeah. I wonder who that is.
So can we say the first step would be to convene?
I agree with that.
Any disagreement? All votes counted for?
Monkey in black over there says no.
Excuse me?
So the monkey in black on the bench says no.
He's allowed,
He won't.
but I don't see the value in his allowance. I'll take it back and count it twice for him. It'll count him twice as much for me counting it. Aw. Standing would be perhaps the second, and we're gonna memory peg with Keating, because that's the material that I would like to maybe offer as a good entry for an EOL. Is that agreed
Yeah.
upon? Does that
Yeah.
have some?
Actually, Jonathan has a preamble as well, Alan, did you see?
Let's compare that now. Could we?
Yes. This is what we want.
Know ye that I, Kent Spling Walter, the House Walter, under the expressed authority and by command of Robert Douglas Nicholson, holder of office of Minister of Justice and Attorney General of Canada, and under the expressed authority and by command of the office of the Minister of Justice, Attorney General of Canada.
No, that's not the one.
That's not the preamble.
It's on that handout he gave you.
You're looking at this?
Court suggestions.
Declaration?
No,
No.
no.
Court suggestions, no, I, sorry.
You have that one, Ken?
I don't know.
Don't have that?
Is this part of the other stuff?
No, that was Rob Young's thing. That
This is part of our thing.
Okay, the court, do you have it?
The ye part, right?
Which-
It's your affidavit.
Yeah, which one is it in?
The preamble was,
It's the one with the questions on it for the judge.
Phrase that.
No, it's
Oh,
not.
no, I
it's
don't
not
have that.
part of the
The
document
judge
itself.
don't like that.
I don't have that one with me.
If he doesn't like that and he wants to go, then say,
Or
excuse
he
me.
gets into that stuff that I don't understand, your
Well,
language
It's,
and.
yeah, it's the
I
guy
have that on
for,
my flash drive.
Yeah, I didn't get that.
I don't know if I
I'm gonna-
got it.
Yeah, I didn't bring it with me, I forgot
It's on your
it.
flash.
I haven't got that yet, because I haven't started reading.
Yeah.
Al?
Well, some of that
Granted
stuff is
permission?
pretty good.
I like that. I'm gonna put
He
Al.
gets into saying, I can't, I'll give you, I'll give you, I'll give you, Jack, yeah. All right.
or we can look at it tomorrow. I can bring it.
Gift is,
Can I have the floor for a moment, please? I'd like Al to enter what he's offering at this juncture. He has the capacity to convene under agitated position.
Under what?
Agitated. He's becoming the judge.
Adjudicate.
In the right of the Donald Allen Lorzell, Judge Donald Allen Lorzell presiding.
Would that give high standing? Isn't that the standing we want to execute from?
the executor, okay, is this getting into, maybe I'm splitting hairs here, but the executor cannot occupy two different capacities at the same time.
Why not?
Who says?
You're there as the
you a
trustee
dad?
and constructive trustee.
Are you a dad?
Yeah,
Can you drive a truck?
yeah.
Okay, you're occupying two different,
Occupations?
No.
Even our premier of our provinces do that. But what I'm saying here is when you're
Public
doing
and a
that,
private.
are you not coming in at the highest authority is what is highest authority? Rule 144 says you are the judge.
But if you're, if,
Let's hear Tim here.
Hang on, look, the answer to that is to understand, when you're convening a court, executive office is an
Right.
office of law, of the court, right?
Right.
So,
an officer of court.
right, so you do convene the court then, aren't you?
You're taking
Right.
client's
You're
office.
standing as the executor, you're just filling the position
That's what we
of the
just
court
said.
that you just convened.
That I am before
I think we
this
have a
court
very
of
good
record.
point. It's not their court, it's whose?
It's your
Your
court,
court.
it's your
Yeah.
court.
You're making the
You're
rules.
presenting.
But this, right, this what I hear takes care of that. It doesn't say you're the judge.
Go over it
says you're the
again,
executive.
go over it again, let's see if we
Good,
find
that I
any
am before
discrepancies.
this court of record by special appearance, or I like special visitation, I give optional appearance, and by oath of office as the executor, and without waiving any claims, rights, remedies, or defenses, statutory or procedural.
Either one is advocating the highest position.
Yeah, that covers it, I think.
But if you're having trouble when you convene the court, if you're having trouble, and they
Okay,
do
but
what the judge wants to.
Here's an
we're not talking about
assurance
court, We're talking
factor.
about creating this document,
Yeah,
okay, which is the court, that, you're that.
and he's
that-
right, we're on the paperwork, we're
Yes.
not in the theory just yet.
Right.
Indeed, what you have is a lot of experience for the encounter in the room.
Right.
We don't want to
We don't
go
want-
there.
You wanna go before.
Yeah.
Yeah, this is to preempt that.
And you're
But I want
valuable
you sitting on the
because
bench from locked
This is
doors.
where they point their guns.
Yeah.
So the
I want
point
Rob
is,
Ward in
you
our
want to
group.
put what he's talking about onto the paper then. Because what he's talking about is to stop it before it gets going.
So he hasn't lost any status by taking
doing
that
that.
status.
But
He's just saying if he
convene-
comes, this is he's the because judge.
Okay, but what I'm answering is, look, because
Yeah,
what you're saying,
Charles.
there's two hats, you know, about not wearing two hats and that. All I'm saying is when you convene the court, you're not wearing two hats. You're doing what you should do to wear the one hat of the officer of your court, the executive office.
Right.
You are
So that
correct.
is the highest authority, right there, you've done the.
That's
convening.
good if the
You have
paperwork is
standing,
heard, and he comes in if the paper is not heard.
Right.
So you have to be able to repeat your paperwork.
Yeah.
Thank you.
Know it.
You have
Stand.
to, you have to know it, so you can stand on it. If you don't know
You
your
have to stand on it.
So I'm just gonna put convene, and we have two options. I like that, options are good. That does cover what Al is talking about.
Yeah.
Al is
I
not
think so.
wrong and you're not wrong. I want the paperwork to speak so I don't have to, like Al's experiences.
Yes.
But we can call on Al if we need him.
But you complete
You
the
can
sentence and
call
close it.
me, Al.
All right.
So in there, would you then come, if you don't wanna wear two hats, right? You wanna wear one hat? Do you
Well,
come in
look
here
at
and
it,
say,
look at it, okay, you can wear two hats, but look at a police officer and a peace officer. They're not wearing both those, they switch them like this, but they're not wearing them both at exactly the same moment in
Yeah.
time.
And they're only doing the opposite of what you're playing them for.
Yeah.
And so he's good at that, he's seen that, he's experienced it. That is the other side of the mirror that we're using the paperwork as a hammer to deal with now.
Just like, remember Green Acres, they posted up the ad in the store? What he was doing, he was switching hats, but he never wore two at the same time.
well, neither is the premier when he's the minister of agriculture.
Public and private life, can we say it that way?
But, okay, now, if we're doing this paper,
That becomes a
are
public
we
issue.
coming in from which side of the estate?
It becomes a public issue, but it's a private matter because it's under
So would that
a
be-
one-on-one
You talked
contract.
about the marriage. Now, would the marriage be head estate?
I would have to agree, and the head of state is the paperwork that's speaking for both parties.
So that'd be a head estate, not executive.
No,
It's
but
taking the
we're-
stance of the direction you must both follow.
Another way to put it, maybe simpler, would it be coming, because I've had great success, and you've got a paper to prove it unduly.
Duly authorized.
Can we get a copy of that on the
If you
table
get-
at some time?
Yeah. Because that's important, there's duly, and if you read that other
Please.
one we had, we've got
Okay.
two executive offices happening at once, the private and public. It is really clear in that one thing that you had.
So you just sewed it together with the marriage of becoming the judge because you advocate the issue.
Right.
Does what he's just done
That's what I'm
in its
saying.
status do the same thing?
That's what I wondered.
It does, and you're only good for contention. So far, that hasn't raised any.
Okay,
I'm keeping you on the sideline for option.
Corpus juris secundum says, an executive or administrator, as an official and as an individual, is legally two separate persons.
Bang.
What page is it? Legal. Well, that's right.
They're on the front page.
But it also says,
Legally, two separate persons. As an official and as an individual is legally two separate persons.
Because you're a legatee, which means you're under succession. You're the surrogate on the contract. And that's okay. Because you're also the father of the
and
child.
this is where I get that there has to be two executors.
Sorry.
Because in the
Last
executive,
page.
it's doing-
Okay.
Already signed it.
And that's
That's
why.
why it came from CRA.
The deceased. I'm going to read a little quick something here. Section 1082. At common law, the executor
That's the way we signed it.
or
That's the
a deceased executor succeeded, there's a surrogate position, as the executor of the will of the first testator. Stop. Do we understand what that means?
You guys,
Hey guys, listen to this.
Yeah, I want to hear it.
Hard to hear it with the mouth open. At common law, the executor or a deceased executor succeeded as the executor of the will of the first testator. Where the rule prevails, an executor of an executor may sue for, seek leave to sue on behalf of the estate, may sue for the construction of a will for which his testator was the executor. However, the doctrine has not followed in most jurisdictions, and an executor of an executor cannot maintain a bill for the construction of a will of which his testator was executor or executor and legatee, because he does not succeed to the fiduciary position of his testator. In brackets, does this indicate the power of the first executor exceeds the power of the second?
First in line, first in time.
And what you were saying was if your paperwork don't come in, you can grab this option to adjudicate.
Right.
That would be warrant the issue. And we're going to adjourn after standing is noticed.
yes, no from understanding. Head of state, okay, visibly in line, head of executive office. Head of state is the individual that serves as a chief public representative of a monarchy, republic, federation, commonwealth, or other kind of state. His or her role generally includes legitimizing the state and exercising the political powers, functions, and duties granted to the head of state in the country's constitution and laws. In nation states, the head of state is often thought of as the official leader of the nation.
Finished?
Yeah.
Thank you. I've been in court and I've been told, you come from a separate mind.
Yeah.
My brain was thinking, did you get my postcard? But I don't often say sometimes what I think of first because I know the forked tongue's got him in the eyes already. And I don't want that for me because he's part of me and I must watch that. So, to a degree he's not wrong and I won't admit that he's right. So I just go with, yeah, in a juxtaposition perspective. We're both right. But sometimes there's a question of who's more right. It's not hard to tell who's right or wrong. The hard part is picking which wrong is more right.
Who's got the most equity?
That's best put.
Who's got the most what?
Equity.
Mhm.
Which of course is you if you're in the right position, standing in your shoes.
Or who has the law on their side?
So in other words, when the mind and the corporation are merged as one. 621 Criminal Code. Anybody? We're going to prove to you that you cannot deny you are a corporation. Or at least you are recognized as the status of such.
Well, we have invested interest in both the states, the private and the public.
Yes, those are your two statuses.
Notice to organization.
The clerk of the court and the prosecutor may, where an indictment is filed against an organization, cause a notice of the indictment to be served on the organization. Contents of notice of an indictment referred to in subsection 1 shall be set out in the nature of report of the indictment and advise that unless the organization appears on the date set out in the notice or the date fixed under subsection 54821 and enters a plea of not guilty will be entered for the accused by the court, and that the trial of the indictment will proceed with as though the organization had appeared and pleaded. So when they're talking organizations here, you're talking the marriage between mind and state.
Yeah.
Fuck.
That's how it starts. The French seal.
Fuck.
Fuck sealed your death
Fuck.
if you don't accept the marriage.
And then unless the corporation appears and pleads within 7 days after service, a notice of plea to guilty will be entered before the accused by the court.
Summary.
So that's a
And
little bit
proceed as
more.
if the corporation had appeared and pleaded. Well, what does it say in here?
Because you have 7 days to set the order aside, to come in, to appeal.
That the defendant is constructively before the court.
Constructive trust. Ain't no denying it. Once there's information, an informant prefers an indictment. There's a lot of value in that. It's got to be settled. We're aiming at using our paperwork to do so. Al, you've had much experience. I appreciate your insight. Al's our backup option at this juncture. He has the verbiage that can enforce the understanding if we do get a, I don't understand what you're talking about, which is often the case. Because what we're doing here is to get the paperwork in. Can we call you at the wee hours, Al?
Absolutely.
Thank you for your love. Al's in the family. Because at any time, somebody having a little issue in court, could they ask for a little, maybe recess to call Al?
No, absolutely not. I don't want him in here.
Then I seek leave for what?
Until it gets sealed.
Thank you. For what?
The matter of law.
In a matter.
Shit, you just got me by my and I gotta follow you.
This is the interlocutory appeal you were talking about, which should put the matter on hold until that's done. That should really.
It's a voir dire, whatever we're calling it.
What year?
Who does not know what that is?
What's the word?
Voir dire. It's French for show and tell.
Yeah.
Trial within a trial.
Trial within a trial to accept what evidence.
Trial to accept.
The only evidence we're discussing is that. The stuff you're saying you're blind to. Are you denying me my rights when I call voir dire? That don't make you look too good, Judgy Poop, does it?
Right.
And as soon as the word appeal is on the record, what happens to his conscience? It gets engaged for a reversal of a decision, a reversionary process, a right of entitlement to adjudicate in your favor the living individual that is the plaintiff in fact. What fact?
Conscience.
That.
Consciousness.
So we know we're a corporation, we gotta act as one, especially when we're in there. Corporations don't speak, they let the instruments speak for them in a testamentary capacity. Making sense? So, as a good sovereign corporation, let us continue breaking that apart, putting it together. So far we got convene, we got standing, we all agree that Al is really good when it comes to the verbiage. He's had the experience, that's what giving him that qualification. And that we understand we have the option of, I'm feeling a little duress, I gotta go get some good advice from the proper investor. Gotta go convene with God, God's word. And Al's got the verbiage, so we understand that paperwork's going in for testamentary capacity. We're grabbing the convening of the court by covenant. The standing which is in there comes from Keating. We're going to be mixing a little in the EOL, so I want to keep putting where we get our information from and what we're putting it into. We're tearing apart Jonathan's paperwork. Or,
Eventually.
in a sense, not tearing apart, no offense, Jonathan. We're adding quality.
Seeking to it.
We're amending.
Well,
Constructive
on that note,
criticism.
can I say
criticism.
something here?
Yep.
He's got a whole bunch of documents.
Sure does. I
You've
want to
got
hone
this
it down, boy.
Affidavit of appointment, and yeah, I don't think that you need to have all these documents. And I think this affidavit of appointment, well, I don't think it is. To me, it doesn't make any sense. To me, he's got the appointor being the Attorney General of Canada, Minister of Justice, and him as the appointee, and then he's having this
That's the
thing. that's appointing
donee
him.
process.
Yeah, but it's having the Attorney General of Canada appoint you as the executor. Well, that's not who's appointing you as the executor.
You are.
You're appointing
You are.
You're
The
the
testator.
testator.
Hold, please. Where are the Sister Key trusts maintained? In your domain or theirs?
But the Sestakay trusts only operate because the executor has failed to come forward.
But
You're not asking them to name an executor so the Sestakay trust.
It's this, all that explanation, what's been explained here is the same as seeking leave. It's their property, it's not ours.
That's right.
We're just filling an office.
because
We have that right, then we get
Okay.
a little
Yeah,
controlling,
state.
we get a little controlling interest at that juncture, like
Okay,
51
so-
instead of 49.
So if we have a.
Yes, it's the estate of.
You can't call it the, or your estate,
No.
it's the estate.
It may be the estate, but it's not, they don't have jurisdiction over it, you do.
well,
It's a floating
they do until
jurisdiction.
they do until you go and get it.
Which
They
is,
do by default.
and if you're
because of the
denied, you gotta
absence.
seek leave.
Right.
Okay,
Look,
That's
look,
agreement.
No, look, it's not, it's being denied, which they have because you are in at the moment absent from the position.
Yep.
How do you become not absent from the position? By letters testamentary.
Yep.
Where do those originate from? The testator.
Yep.
Who is the testator?
right, so
So who
Silence is acquiescence.
provides the letters of testamentary?
In my mind-
Appointing the executor.
in my mind,
You
we have this document.
Absolutely.
This
For
letter,
the purposes of
basically,
recording, it's best if just one talks, it'll make a lot more sense.
Appreciate that.
I see a letter rogatory or something of similar nature going to
Letter of credit.
letter of credit, letter rogatory, I don't know, whatever we decide, documentary letters of, I don't know, whatever we decide the title is, whatever it goes in, whatever form it goes into the Governor General and the Attorney General and the Minister of Foreign Affairs. That document goes, and with it should go a letters testamentary
Yes.
appointing the executor, and the letters testamentary has in it, is available to be signed by the Attorney General or the whoever, and then it says that if they don't sign it, then you can have in there, and if you don't sign this and return it, then we'll sign it on for accommodation for you.
So
By
in the
accommodation.
third step, we want to put,
Signed by accommodation if they don't sign, but the sign
Because
is approval
Your,
aspect.
like they call this one affidavit of appointment, and then you got all these documents, like I say, you could call it that too, or what did someone say, what did you call it the other day?
Oh,
Letters
notice
testamentary.
of affidavit of